Thank you, Mr. Chair. I'll just offer a few thoughts. I mean, there are profound philosophical differences on the subject of crypto, and there's almost no point in relitigating those differences because it's been extensively debated here today. But I find myself unpersuaded by the notion that the status quo is working. You know, a status quo that gave us the largest crypto Ponzi scheme in history is not working. It's by definition failing. My assessment is that the status quo is dangerously deregulated and requires regulation. Albert Einstein said, if we do the same thing over and over again and expect a different result, that's the definition of insanity. And the time has come for us to break the cycle of insanity that governs the application of securities law to digital assets. Now, there's a difference between securities law as we as individuals might think it ought to be interpreted and securities law as it has been interpreted by the courts. And the Southern District of New York has held that securities law protects institutional investors in ICOs, but fails to protect retail customers on exchanges. The SEC could, in theory, appeal, but an appeal would take years. So regardless of one's personal view on securities law, we have a status quo in which institutional investors are protected, but everyday average Americans are left exposed. And the choice before the committee in the world as it is whether we should maintain that status quo or change it to fill the gap in investor and consumer protection for everyday Americans. And I believe we should change it. Now, there are those who argue that there's no need for Congress to act, that we should leave it to the courts and the regulators to figure out the application of securities law to digital assets. One of my frustrations is that Congress is often the most powerless, powerful institution. You know, we as Democrats argue that we've ceded far too much authority to the courts, particularly the Supreme Court. Republicans often argue that Congress has ceded too much authority to regulators. We can reclaim as our authority as a legislature by actually legislating. And we should legislate with respect to digital assets. Now, there's a concern that the legislation would circumvent the Securities and Exchange Commission. That is not my reading. I read the bill to codify the SEC as a regulator of digital assets, right? The bill essentially holds that a digital asset is presumptively subject to the jurisdiction of the SEC until it is shown to be sufficiently decentralized to constitute a commodity. That's not a circumvention of the SEC. That's a codification of the SEC's authority to regulate digital assets. You know, I heard a concern earlier that a corporation like Apple can tokenize stock. A stock is inherently a security, regardless of whether you tokenize it. In fact, the legislation says the term digital asset does not include any note, stock, treasury, stock, security, future, all the traditional securities. So the legislation does not apply to traditional securities. There's a difference between a security in itself and a digital asset that's offered as part of an investment contract, which is a security. There's concern about the safe harbor. My understanding is that the safe harbor offers no protection to any bad actor who perpetrates fraud or market manipulation or misappropriation of funds. Right? A bad actor like FTX and Sam Bankman-Fried would not have benefited from the safe harbor contemplated in the legislation. And there are legitimate concerns about regulation by enforcement. The SEC has not issued a single rule clarifying the application of securities law to digital assets. There's been no written guidance. We've heard mixed messaging not only between the CFTC and the SEC, but within the SEC itself. The CFTC tells us that Ether's a commodity. The SEC has said that it's a security. Mr. Gensler first said that Ether's too decentralized to be a security. Then he said it was a security, and then under questioning from Chair McHenry, he said that it depends. I mean, if you consider that regulatory clarity, then you live in a different planet from me. I am confused by the mixed messaging, by the lack of rules and guidance that have been provided by the agency. And this legislation is far from perfect, but it represents a good faith attempt to bring clarity to an area where none exists. And I associate myself with the comments of Congressman Himes and Congressman Nickel, and I will support the legislation. I will not let the enemy, the perfect be the enemy of the good.